Hello, it's Phillip Taylor from Richmond Green Chambers in London speaking, and it's my pleasure today to look at an important practitioner book. It's in a difficult area of law. It's the Court of Protection Practice Handbook, if you like, for 2019. It includes a CD, and it's been edited by a large number of people, the main editor being Jonathan Baker. More about him in a minute. Elizabeth wrote the review this time as the lead writer, with a fairly substantial discussion with me about what we would put in and where we're coming to with the book. It's from LexisNexis. We've given it a title for our book review, The Definitive Reference Work on the Court of Protection, now in a new edition for 2019 from LexisNexis. And that's really what you're getting with this work. We've reviewed it before, and I'm really pleased that we do have these books, because this is a particular practice area that is not well known, because the courts are secret. They take a lot of the work goes on behind the scenes, if you like, because it's difficult work within this particular jurisdiction. But the book itself is very, very helpful. Let's have a look at it. It's a hardback. You can see that hardback there. You can see the list of people involved. But there's nothing on the back, but you see the names there. You can see the shaded areas too, which gives you an idea of what you're looking for quite quickly. Let me open the book up for you. At the back you've got the actual CD itself, and then you've got fixed costs in the Court of Protection. Very useful, always as up to date as it can be. I found this quite useful because with some of the costs regimes today, I find it very difficult to follow some of it. There is a little calendar at the front. And in fact, I'll just go to the back first of all, because what we do need to do is have a look at right at the end, what we actually have at the end of the work, and that's the index itself. You can see the index there. The index is by paragraph numbering. It's not a particularly big index either. Let me just get to the beginning of it there. References are to paragraph numbers. Okay, there we are. Not a big index. And then after that, you working backwards, you can see that we are actually in part 12 here, right at the back of the book. But if I go to the front, the pages are very thin, so be careful, because it's a heavy book. It runs to 2,500 pages, so it's a very substantive work, and it's grown over the years, this book. There's the front, and then after that we get into different areas. There's the blurb at the side. Now you can see the consulting editor, a man known to many of us, is Gordon R. Ashton, OBE, and the general editor is the Right Honourable Lord Justice Baker, Jonathan Baker. And there's a large number of people involved whose names will be known to many of you. And I'd like to thank Lord Justice Baker very much, and all the other people involved, for the production of this work. It does make a great deal of difference in a modern era to have works of this quality. Then we've got an interesting comment going back a little bit from James Munby. Now, Sir James this is from 2015, he's now retired of course, he was president of the Court of Protection and a very substantial figure for a very long time in the whole of this particular area of law. So he's worth reading. And of course, Mark Potter, alas now deceased, actually produced the foreword to the first edition, and Gordon Ashton of course also produced a preface as well, which was extremely helpful. Now the current introduction, which is there, it's actually after the prefaces, is dated January 2019, and it really sets out to explain what is in the new edition. And as I say, most people involved in this area will know about the book, and it's the one that you'll see in the courts as well. There's the content section there. As I say, it goes into 12 different parts. Then there's some abbreviations, very useful. Then after that, statutes, of course. Then after that, you've got statutory instruments. And then after that, some practice directions, quite a lot of them, of course. And then just moving on from there, codes of practice, because there's a lot of regulation. International and European legislation are also covered, and then the table of cases. And again, quite a large amount of information there. Then after that, we get to the contents section itself. So I say the pages are very thin, so take care when you're flitting around with it. This bit's called the narrative, part 1. Excuse me. And what you've got is the contents section. You can see how it's structured. You've got an index there for part 1, the narrative, the contents section. It's looking obviously at the basics. The overview, then mental capacity, best interest, social context, health and social care, and so on. Then it goes on to chapter 2, mental capacity, and so on, and runs all the way through that way. And when we get to the end of that, chapter 14 covers Northern Ireland, right at the end. Now, then you get to the actual body of the copy itself, chapter 1, the narrative, and you can see how it's structured. It's initially, there is paragraph numbering, but it's not in the way you would see it. It's actually indented into the side of the work itself. So it's slightly different from some of the publications you might be used to. Then you do have the footnoting, but the footnoting again is in a different position. So I think it's useful for people to know that. Then running through, you can see it runs all the way through. So that's the house style that LexisNexis have run all the way through. And as I say, it runs to something approaching 2,500 words, something like that, just under. But when you take into account all the stuff in the beginning, it's well over. And there's a nice little divider in case you need to find stuff quite quickly. So what do we say about the book? Well, this. Reflecting on the realities of an ageing population and bearing in mind the attendant medical and certainly legal problems therein, it's reassuring that Court of Protection practice has become the definitive work of reference for judges and for practitioners in the profession. It's basically a very challenging and sensitive area of law, so this book is very welcome, and you make our lives a lot easier. Thank you for doing that. This is the new 19th edition from LexisNexis for 2019. Not quite sure if it is the 19th edition, but perhaps I may have that slightly wrong. But anyway, it's for 2019. Now, Sir James Munby has remarked in the foreword to a previous edition that the Court of Protection goes from strength to strength, he says, having worthily achieved in relation to the Court of Protection the same dominating position as its stablemate, the family court practice. This nice red book here in relation to the family courts. And as I say, this is extremely useful book, again, from LexisNexis, very helpful, one you will see in the courts and one I use regularly. Indeed, the remit of the two courts can inevitably overlap. Certainly that's the case in some areas. And so in the latest introduction to the book, the general editor, Lord Justice Jonathan Baker, refers to reported judgments in the Family Division, which include many decisions of real importance about the Mental Capacity Act 2005 and the inherent jurisdiction relating to incapacitated and vulnerable adults. And it was, of course, the Mental Capacity Act 2005 which led to the eventual publication of the first edition of Court of Protection practice, and it was from that point that this relatively new jurisdiction has developed. So as I said earlier, it's not the 19th edition, it's actually for the year 2019. I don't know how many editions, I think it's probably about 9 editions it's been through. And there are, of course, further introductory comments on recent, current and future developments in what's a steadily expanding area of law. And I raise that because obviously when the first edition came out, it was quite a lot thinner than this. And as I say, at that particular time, this area of law was quite unknown, I think, to a large number of practitioners. Since that time, of course, things have changed. And what we've got now, of course, is that, as is said in the book, for example, 2018 was a relatively quiet year for case law in this field, which gives you an idea of the way in which the subject matter is moving ahead. But let me mention something else. Mention is also made at the time of writing of the passage through Parliament of the Mental Capacity Amendment Act, a process which, like many other pieces of legislation, has been hampered by the bugbear of Brexit. And I don't know at the time of recording where we are with that legislation because of the problems this particular Parliament has had. But of course the difficulty we've got, irrespective of the amendment legislation, is the fact that we need a proper new workable Act of Parliament, which is what these characters in the House of Lords and Commons should be working on, instead of all this other stuff, because we actually need the legislation as a bedrock for the future. And having got that commercial out of the way, we've got this book which at least helps us. Meanwhile, of course, as I say, further developments are to be expected in the future in the matter of cross-border protection of vulnerable adults. But I'm talking about of this review in the summer of 2019. Now, within the 2,500 odd pages, Court of Protection practice adheres closely to its original remit of providing clear and accessible guidance to the principles, law and practice relating to mental capacity cases. It's straightforward in my view as a book. It's written in plain English. It's a nice approach that they have, and it makes it accessible, I think, to novices in this area as well as seasoned practitioners alike. It's not an easy area of law, and of course the problem with any publication today is that you've got to have a certain amount of understanding of the structure. Alas, many unrepresented parties do not have that, have no wish to find out about it, and that does make life a bit difficult for a lot of people. But there we go. That's what we are faced with, and the problem that the judge is faced with can actually be even greater in some cases. So give a poor thought to the judge as well, because of some of the difficulties. The book itself is divided into 12 parts, as I've indicated. Part 3 contains the Mental Capacity Act itself, 2005. Parts 1 and 2 provide the narrative and procedural rules, while subsequent sections include Court of Protection rules, practice directions, codes of practice, forms, precedents and case summaries, followed by coverage, usefully, of Scottish legislation and guidance and international conventions and recommendations. And particularly handy, I thought, are the directories in the final section with their lists of addresses and contact details and website information for a very large number of relevant organisations and information resources. I think that's very helpful, because I do find sometimes actually getting the information, it can be really difficult. Basic contact information is not the easiest to come by these days for a lot of reasons, but that's why in this book you've actually got that information. Suffice to say then that the book covers virtually every conceivable aspect of what's a difficult area of law, from the lasting powers of attorney to deprivation of liberty, and that Dols is particularly of concern, and until you've actually gone through it and dealt with it, it's a very difficult area. There are 6 tables too, over 40 pages of them, including statutes, statutory instruments, PDs, codes of practice and guidance and cases and so forth. Then you've got the EC and international regulations, very, very useful. Forget Brexit, they're going to be around for a very long time, and very important they are too. Then if you turn to the back of the book, you'll discover the table of fixed costs right on the back page, which goes with the CD. And to say that this volume is a powerhouse of resources is something of an understatement in our view, and even more impressive is the humane spirit, we think, which permeates throughout. It's difficult to believe that any practitioner or judge within the Court of Protection could possibly do without it, and that's really why I say a thank you to Lexis and a thank you to all the people involved, because this is where you find the law and the practice, and that's how we do things. So a big thank you. The date of publication of the hardback edition is cited as at the 19th of March 2019. Let's have one last look at the book. It's a heavy book. Be careful with the pages there. You can see it's a hardback. Spine, nothing on the back. Just opening it in the middle. Let's find the middle bit. This is part 5. This is Public Guardian Practice. A lot of detail there. And again, you can see how the structure of the book is, again with the paragraph numbering. It's slightly different from what you would normally be expecting. Law Society Practice Note of the 10th of November 2017. So there's a huge amount of detail here, which may be very specific to the instructions you have in a particular matter. But there it is, a very good book, and as I say, I think it's invaluable for practice in this particular jurisdiction. Thank you very much to all concerned, and I'm looking forward to the next edition in due course. Bye-bye.